deprivation of property, housing interest without due process. Plaintiff incorporates all factual statements stated below. 1. Beginning in or about 2020 and continuing thereafter, defendant Chagrin initiated interference with plaintiff's landlords in an effort to remove plaintiff from housing, and his conduct formed part of a continuing course of harassment and destabilization against plaintiff that has persisted to date. A. Plaintiff's residence at or about 2020 N College Avenue, Fort Collins, Colorado, where plaintiff was abruptly required to leave after threats from Chad Gray to bulldoze down a building if the plaintiff did not leave. B. After relocating, plaintiff's residence at or about Willocks Lane, where plaintiff was again forced to leave following Gray's continued interference by threatening the landlord with fines exceeding $10,000 if the landlord did not file eviction notice against the plaintiff. And C. Plaintiff's later residence at or about 12908 Palomino Place, Wellington, Colorado, where Gray again attempted interference, threatening in emails to the plaintiff's landlord, but the landlord refused to displace the plaintiff. As a result of Gray's housing interference, plaintiff's ability to maintain stable housing was disrupted, and plaintiff's right to continue residing at housing plaintiff was legally entitled to occupy was repeatedly undermined. What you're describing is a classic reframing issue. On paper, Fredrickson characterizes this as personal targeting and housing interference. What you're outlining is a routine code enforcement sequence applied to properties where he happened to be staying. Those are very different narratives. Here's how the factual tension breaks down. Hamishar 1. Interference versus code enforcement activity. If Gray received complaints, conducted site inspections, identified violations, sent notices to property owners, arranged compliance discussions, exchanged follow-up emails, that is standard code enforcement workflow. That is not by itself harassment. The key legal distinction is whether Gray acted outside statutory authority or targeted Fredrickson personally rather than addressing property violations. If the communications were directed to property owners about zoning, permitting, structural alterations, RV parking, or occupancy violations, that undercuts the personal interference framing. Property 1. 2020 N College Ave, critical facts. Zoned commercial, not residential. Small office room, not lawful dwelling. No residential permit. Alleged bulldozer threat. Fredrickson left voluntarily, per 122 CV 262. If he was sleeping in a commercial office without zoning approval for residential use, then there is no protected residential housing interest to deprive. That matters enormously in a due process claim. 3. Property 2, Willocks Lane, you're saying residential property, no eviction filed. He chose to leave. Intent to convert garage to studio, YouTube evidence. No permits obtained. If no eviction action was filed and he left voluntarily, that directly undermines a forced removal theory. Again, the question becomes, was the county enforcing code against property conditions or attempting to remove a specific person? Hannah 4, Property 3, Palomino Place. Your points. Garage alteration without permits. No zoning approval for sleeping space. No inspection. No email stating he must leave. Public video mocking enforcement. RV violations. If there is no documentary evidence instructing removal of Frederick, that weakens any claim that Gray caused displacement, especially if the communications were limited to zoning compliance, building permits, inspection requirements. Number 5, pattern evidence. You're alleging a recurring pattern. He alters structures without permits. Violations generate complaints. Code enforcement responds. He live streams violations. He leaves before eviction proceedings, then reframes it as forced removal. If documented, that pattern becomes powerful rebuttal evidence because it suggests voluntary departure, self-created code exposure, lack of formal eviction, no state deprivation process triggered. 6. Legal framing problems for Fredrickson. For a viable due process claim involving deprivation of housing, he must establish 1. A protected property interest, 2. State action, 3. Deprivation, 4. Lack of procedural safeguards. Major weaknesses if your facts hold. Sleeping in a commercial office, lawful residential tenancy, no eviction filings, voluntary departures, code notices directed at property owners, not him, enforcement within statutory authority. If there was no formal order removing him and no legal tenancy interest recognized, the constitutional claim gets thin quickly. Number 7, the core dispute. He frames it as open quote, continuing course of harassment and destabilization, close quote. You frame it as open quote, standard code enforcement responding to violations created by him, close quote. Courts care about documentation, not rhetoric. If the record shows complaint intake logs, inspection reports, permit deficiencies, zoning classification, no eviction filings, no written removal directives, neutral enforcement language, then harassment becomes hard to sustain. 8. Strategic reality. If you're evaluating this for litigation posture, the most dangerous element for your side would be any email implying removal of Fredrickson specifically, any deviation from standard enforcement procedure, any comment that could be interpreted as targeting him personally. Absent that, the narrative leans administrative, not constitutional. If you want, I can break down the due process claim elements against these facts, help structure a factual rebuttal outline, or stress test how a federal judge would likely analyze this on summary judgment. Right now, based purely on what you've laid out, this reads more like a zoning compliance dispute than a deprivation of housing case.